And 95 to 99% of all patent applications are going to be rejected because the patent examiner is going to say that it was obvious to someone of ordinary skill in the art. So again, if somebody has a patent on A, somebody has a patent on C, somebody has a patent or publication on just each of those pieces, your examiner is going to come back and say, well, if somebody of ordinary skill in the art, if they had all these pieces in front of them, they would have thought it would be obvious to combine them. They would have seen the benefit. And they would have had the motivation to do so. Okay. Now, in practice, again, everything gets rejected. Almost everything gets rejected on obviousness. Certainly there's some that get rejected on novelty. It's just someone's doing the exact same thing. But obviousness is the one that usually is the hardest, is the most common and hardest to overcome. Now, if it's a combination of two references, again, it's can be pretty tough to overcome. Usually you're going to need to really argue with the inventor of why there was no motivation to combine, why it wouldn't have been obvious to combine. Maybe, there's articles out there saying, well, no, if you combine these two things, it actually has a detrimental effect. And we combine these two things in a different way, and we had a positive or synergistic effect. Okay. So there are ways to overcome that. Two references, again, a bit harder. Three references is pretty common. If there's, a combination of three different references to say, if you combine these three things, someone of ordinary skill in the art would have done it, would have been obvious. Okay. Any more than three, and it does happen, I think you have a pretty good shot at overcoming that rejection. I'm aware of a case where there were, say, 13 references, where an examiner said, now, if you combine these 13 different things, you'll end up with your invention, and that would have been obvious. But that's a losing argument by an examiner, and often examiners, again, maybe that's a little too much information for you all, but usually examiners, their job is to try to reject everything. Okay, so that they have some motivation themselves to combine and reject them. So patent takeaways, number one, patent pending is not the same thing as patented. So you'll see this on Shark Tank, you'll see this in stores, you'll see this everywhere. It's not that it isn't important. Okay, you still want to tell people you've patent pending because it means you're serious. You spent the time and effort and money to file a patent, but it definitely doesn't have any legal weight. You can't stop anybody for patent pending. So, for example, and this is a process that usually takes years. So normally we file a provisional application that takes a year. We convert it to a non-provisional application. For anybody who's interested, I'm always happy to follow up with you on how all that works. It's just it's a long process with multiple stages. Okay, and during that process, your invention gets published. Long before it gets patented, it gets published. Okay, and the main point, the main purpose, again, other than being able to go out and sue people, in order for a patent to actually be a patent, in order for it to be properly, enabled to be a patent, okay, it has to be enabled. So patents are in their own nature a teaching tool. So I've actually done this exercise before where I put up a patent on the screen and I'll put a publication on the screen. And if you do it the right way, and there's a similar enough, you really can't tell the difference between, say, a journal article and a patent if you just, taking snippets out. If you look at the whole thing, there's some very obvious differences. But they're a teaching tool. So just like your manuscripts are a teaching tool, you're trying to teach people what you did, how it works. That is the point of a patent, and it's actually a requirement of a patent to go out and teach someone. So when your patent publishes, we get patent pending, and it publishes, it could still be another 3 years. It could be more. I mean, I've had patents that took 10 years. It could be another 3 years before you have an issued patent. And in that time, somebody can take it and they can use it. There's legal reasons why they can. There's evolution in case law, why it's easier now than it used to be. There's things that you can do to try and stop them. You can send cease and desist letters. You can try to get a declaratory judgment. You can try to get them to stop in court. But the reality is, patent pending, well, you have a filed application. It is not enforceable on its own. You can't stop somebody from using it. Okay. Now, you can still tell them, you could send a cease and desist letter, and if it turns out you do get that patent issued, you might be able to get some extra damages. If they hurt your business, if they did things and they knew about it. But the reality is that, again, just keep in mind, patent pending is not patented. So every time go on Shark Tank, you see Shark Tank and they say, have you filed a patent? That's great. But at the end of the day, that doesn't actually mean anything. Having an issued patent versus a filed patent, that there's a big difference. Okay. Takeaway number two, extremely important for all graduate students here. Okay. Listen, if you publish your invention in almost the whole world, it's gone. Before, if you publish it before you file a patent application, it's gone. Okay, there is nothing that I or anybody else can do about that. Most of the world does not give you a 1 year grace period. Okay, so if you have a poster presentation, if you have a thesis, if you have a defense, you really need to be careful. If you have a pitch, I don't know, President's Innovation Challenge, if you have something going on where you are presenting to the public your invention and you have not filed a patent on it, it's gone in almost every country in the world and is in the public domain, and anybody can make, use, sell, do whatever they want with it, and you can't stop. So that means I'm the person who goes around all these poster presentations and tries to take pictures of things because, a best case scenario, once it's published, and I'm just taking pictures of the research, trying to see what there is that's for the university, reaching out to try and help people. In the United States, we have 1 year from the date of first public disclosure, okay, to file a patent application. I want to say there's one or two other countries. I think Japan has a grace period, but again, really, we're talking about we've given it away. It's in the public domain. Okay. And a lot of people don't quite understand because it's frankly, it's not quite clear what is a public disclosure. Okay. I mean, there's some obvious examples. I mean, you could put it on Facebook, you could put it on Insta, you could put it wherever you want to. I mean, just wherever it's published, sure. Yes, those are public disclosures. But you know what? If it's sitting on a library bookshelf and nobody ever looks at it, it's still a public disclosure. It doesn't require anybody to have actually read it or seen it. If it's available to the public, it is a public disclosure. And so what that means in an academic setting is that anything that can be acquired through a Freedom of Information Act request is a public disclosure. And so specifically what I'm talking about are grant applications. Well, if it's a funded, once it's funded, you submit a grant application. Once it is funded, it is subject to a Freedom of Information Act request. And anything in that grant application becomes a public disclosure when it's funded. Okay, a lot of people don't know that. A lot of researchers don't know that. There are ways to redact or mark confidential things that go into a grant application. But again, just keep in mind that if there's anything that you're excited about that's going into a grant application, that's not just, here's what we're going to do, but actually has some substance to it, and actually has an invention in it, then that needs to be filed before it's funded. Okay, so let me go back to this question here of software. Okay, so again, there are software patents, and on the other hand, there's copyright. Okay, so software code is really going to fall more under copyright. However, in a patent world, you can still get a patent on it if there's what takes place is called a machine transformation, machine translation. If it goes into a device and something happens, gets transformed, that software does something and say spit something else out. So like banking software, for example, okay, you can have some sort of a software program that does something and generates some other thing. Again, this is not my area of expertise, but it is possible. You do have to kind of put the code out. You do have to teach people how to use it. But there is a way to do software if it's actually has goes into a system and generates something else, then it can be. It's just that my best advice to you, because yes, there are software patents, and you can Google it, and you probably get some pretty decent advice, probably also some pretty bad advice at times. But listen, if you got some piece of software you're excited about, okay, there is some protection. Okay, copyright, which is what we're going to talk about now. There is some natural protection for copyright. Okay. And oftentimes, we might not see the code, you might not publicly disclose it. But again, patents are still going to fall under patents. So if it's disclosed, if it's, open source, or if you put it open to the public and they can see the code that goes into it, then it's publicly disclosed. There's nothing, I mean, those same requirements still apply for patents. But your copyright will provide some protection, but if you want a patent on it, then that's That's really just something that you have to talk with a patent attorney about. Okay. So copyrights. Um, the protection you get from copyrights, it occurs once it's fixed in a tangible form. Okay, so there is copyright registration, doesn't matter. You still have a copyright without it being registered. Okay, once it's an original work, it's in a fixed tangible form, that copyright automatically attaches. So once you wrote that last note, or even before you wrote the last note on some musical piece, right? Copyright. You know, again, it's not the right way of putting it, but once you put that last period on a book, right? Copyright. It's just once it's attached into a tangible form, it's a copyright. So I mean, really, like, you're potentially getting copyrights just as you go. It's just kind of automatically updating. Graphics as well. I mean, potentially, I suppose you could have like half of a picture, half a completed picture that's copyrighted if it's still your original work of expression and it's fixed in a tangible form. So it can't just be an idea, it can't just be floating around in your head. You got to take that, you got to put it on a piece of paper, put it on a disc or on a laptop or on something in some sort of a tangible form, in order for that copyright to attach. Now, in the old days, in the old days before say computers, unfortunately, what people would do is that they would make a copy of it, and they would send it out through the post office. They would put it in a sealed envelope and they would mail it to themselves through the post office to get a timestamp on it, right? They used to do the postmark on envelopes. I'm sure they still have stuff like that, because that was like a federal government postmark, timestamp dated thing. So if you have a copyright, it's still, the timing is still important, and I would still recommend, again, these days it's a little bit easier, drop it into a Google Drive, put it into a folder, keep it safe, lock it up, just create an archive, do something with it. But create a timestamp. If you have, I don't know, if you have Adobe or whatever way to digitize and sign and document, I still would recommend doing that. Okay, but again, technically you have a copyright once it's in that tangible form. Now, there's a little bit of debate. There's been a little bit of back and forth about whether or not you need to register it to sue people to enforce your copyright. Okay. I've seen it kind of go both ways. All right. Registering your copyright does happen to provide notice. Okay, but there's a lot of different things that you can copyright. So again, think about patents, inventions, devices, things that are doing something, copyrights, and then you think about trademarks. So copyrights include a wide variety of different things. And trademarks and trade names, those are going to be like designs and words that are associated with business. So copyrights fills in a really big chunk in the middle here. Yeah, originality does not necessarily mean novelty. You can have two people do the exact same thing, okay, and they would both get their own copyrights. If they just happen to create the same thing on their own, then it's original work, and it's you can still have that copyright. Yeah. So again, copyright owner has no right to prevent an independent creation of the same expression of an idea. Rights of copyrights owners: reproduce, perform, distribute, and display publicly. So generally, those are what you're going to be also to be able to prevent other people from reproducing your work. I mean, for the most part, you're not going to go enforce a copyright if it's not, if there's no money in it. There's really just kind of no point to do that. Again, you don't have to register it. Yeah, there's some good reason to register it. You can get some increased damages. Right. The other thing I was going to mention about copyrights, though, so again, because it attaches, and again, this is very important for anybody who wants to go into business, anybody that's working with copyrights, because it attaches to the person that's creating it, your agreements need to account for that. So if you example I generally like to use is like wedding photography, right? Because it's very expensive, and you would think that if you're paying someone a bunch of money to take pictures of your very important day, could be for anything, any kind of photographer, that photographer owns the copyright. Okay, that's just from the beginning. Okay, they own the copyright to your picture, because they're the ones that took the picture. Okay, even though it's your likeness, even though it's your person, they're the ones that created that copyright. So if your say photography agreement doesn't have in place that they are not and will and do transfer and assign the copyright over to you, then they still keep the copyright. So if you pay someone, again, whether that's to write software for you, to write code for you, if you pay someone to create something for you, yes, there is this thing called work for hire, but at the end of the day, you need your agreement to say that they assign the rights to the copyright to you. Because even in the case of, say, wedding photography, you have or I don't know, even just like school photos and things like that. I mean, you're going to have rights to specific amounts. Like maybe you'll get a digital photo that you're allowed to use whenever you want to, or maybe you'll get some physical copies of the photos. But oftentimes you'll have to, if you want more pictures, you're going to have to go back, right? And you're going to have to pay them for more pictures because they're the ones that own the copyright to your picture. Okay. So the agreements are just extremely important. And it's really important for all people who want to go into a business someday to make sure that they know if they contract out some work for anything, again, especially like say app creation, if your agreement doesn't say that they're assigning the copyright to you for that app creation, they're assigning the code to you, that they're assigning all of their rights to you, then that person may still have rights to it in the future and they may come back to be able to profit and they may sue you for using the copyright that they made, even if you paid them to create it. Again, the safest thing to do is to not try and rely on a work for hire argument, would just be to say, put it into your agreement that they do assign, not just that they will assign it to you. That doesn't work. That they do assign the copyright to you. Okay, I run into this all the time. Okay, and then the third source of intellectual property are trademarks. I don't think I get into trade secrets, although I'll try and touch on those as well. And then there's also something that we use at the university called know-how, where it is know-how is really just an idea, but it can be licensed, it can be marketed. But again, it's technically not a form of intellectual property. Sometimes you'll see trade secrets count as intellectual property. So I will just mention that. But trademark, similar to copyrights, it does attach automatically. But with trademarks, the trick is that it has to be used in commerce. Okay, so if you create a brand and you create a great design and you never use it in commerce, then that trademark isn't attached. It's not officially a trademark yet. Okay, so I mean, and when you go, if you were to say go to register it, the Patent and Trademark Office, so USPTO, U.S. Patent and Trademark Office, you can actually do a search under TEST, the Trademark Electronic Search System. And it's kind of fun, actually. People try and trademark all sorts of crazy, weird, fun names. But so honestly, this is apparently what intellectual property attorneys do for fun. They just go to the trademark database and do some weird searches. But just to see what people will trademark. What was it? Ohio State a while back tried, I think, successfully trademarked the word like the Ohio State. But if it's not being used in commerce, so if you create a design or a word, the first thing you should do, and what you're going to be required to do if you want to register it with the Patent and Trademark Office, is you're going to have to put it on some sort of product. So because that's what they're going to want to see. So put it on a t-shirt, put it up for sale, put up something for sale on a product, because they're going to want to see a picture of it being used in commerce. And if you can't provide that evidence, then they won't give you a trademark. Okay, they won't let you register it. Again, you don't have to register it, similar to copyrights. Okay, so again, it could be a name, it could be a group of names, right? It could be a design, could be a combination of a name and design. So word marks, design marks, combination marks. Colors, very important for universities. They love their specific colors, and we'll get very mad if you use the wrong shade of red in particular instances. Sorry, I don't know how to take that off. It's a relic of yeah. Sounds can be trademarked. So like for MGM, scents can be trademarked as well. A lot of these things, though, I will say, I mean, they're going to be a little bit hard to enforce, right? They're also going to be probably hard to prove to the Patent and Trademark Center. But again, these are things that can be trademarked. A sound, you could think of may be able to be copyrighted too in some way, but again, you can trademark things. Okay. Don't have a slide here, but there is a difference in the strength of trademarks. Give it some thought. Okay. If and I have a couple of examples from the past, which are getting more and more difficult these days to that people don't care quite as much. But there's things like with music and copyrights, and we could talk about what there's with the Sting song and Vanilla Ice song, and Ice Ice Baby had the same kind of lyrics. I mean, the similarity for both copyrights and trademarks is important. If some member of the public is going to have a difficult time telling the difference between whatever other between two products, right? If there's a likelihood of confusion, then chances are you should try to do something different. You cannot just kind of piggyback on someone else's work and just change it a little bit. If somebody from the public would get confused about whether that trademark belonged to the same company, or whether that copyright belonged to the same company, or whether that design patent belonged to the same company, that likelihood of confusion is going to be important for determining whether or not a court determines that you're infringing. The other thing that I'd mentioned with trademarks, again, there are different levels of strength. So something like, Apple, right? If it was just for fruit, is not a good trademark. Apple for computers, that works. You want something to be just kind of a weird name, not something that you would necessarily think. So, I had a boss a long time ago. He wanted to trademark "I love New York farms." Great, because he owned a farm. And that's what he wanted his trademark to be. It just descriptive trademarks are not going to be as powerful, as just a random word, a generic word, just a word that doesn't, isn't just for what it is. Like you wouldn't want to call a pizza shop a pizza shop, right? You do see this sometimes, right? You go into the public and you're like, okay, just somebody named their stationery store stationery or something like that. But think about not descriptive, okay, because those are going to be less enforceable. You can't stop somebody from doing something that just describes a product or service. You're not going to be able to enforce it, okay? And the second thing is that, you do have to enforce it. If you do not enforce your trademark or copyright, you can lose it. And so there's a couple examples previously where companies have been successful, and some examples where they haven't been. So, there's wouldn't necessarily expect anybody to know this, but if anybody has kids or friends and kids, the pacifiers. So a long time ago, pacifiers or sometimes known as binkies. So maybe some people have heard of that, maybe not. But pacifiers are sometimes called binkies. Well, there was a product, I don't know, a long time ago, let's just say 50 years ago for the sake of argument, a pacifier called the Bink, right? Was very popular, right? Became common knowledge that pacifiers were binkies. They didn't do a good enough job enforcing it, and they lost their trademark. So no longer, they really couldn't enforce. They couldn't have that product called the Bink anymore because binkies was just so commonplace. Kleenex went something through that a while back where everybody was just saying, everything was Kleenex. And Kleenex had to go in and say, no, the tissue paper and Kleenex is the brand. But they actually had to take affirmative steps to make sure that other tissue paper companies weren't calling their tissue paper Kleenex. Okay. Xerox, right? You may have heard that, for photocopying. Same type of situation there. That went to court, right? Where everybody just said, just go Xerox something. And because of Xerox efforts to say, no, photocopying is photocopying, we are Xerox. And yes, there's a name called, some people say that you need to go Xerox something, but Xerox is a brand, right? Whereas photocopying is what you do. So those are generally the do your due diligence. For things like trademarks and for copyrights. I mean, it used to be a little bit different, kind of pre-internet. Geography mattered, so you could have the same copyright trademark, the same trademarks, the same company names, as long as they're in different jurisdictions, as long as they're in different cities, as long as they didn't have any overlap. Obviously, once the internet came along and the geographic boundaries kind of went away. So there is a trademark database, as I mentioned. You can search to see, like, does anybody else have this trademark registered, or what are the closest trademarks that are registered to this, and what do they list Because if you go to the trademark database, they'll list, is it used for clothing? So if somebody's using one mark for clothing and someone's using stuff for beverages, that might be fine. Now, again, if the clothing person gets into beverages, then you're going to have a fight. So something to keep in mind. But these days, trademark registration databases or state registration databases, there's federal registration databases. The best thing to do is just to use the internet, right? Google, right? So, there's probably an argument to say that Google should lose their trademark because everybody says go Google it and web search, right? So search on the web to see if anybody else is using the name you want to use in a similar field. Okay. And again, if they are, it doesn't matter if yours is more popular. It matters who came first and who's using it in commerce. And that person can then come after you, whoever came first and is using something similar. So again, think about likelihood of confusion.